Good afternoon. This legislative hearing on H.R. 2018, H.R. 2088, H.R. 2119, H.R. 2529, H.R. 3671, H.R. 3876, H.R. 4095, H.R. 4102, H.R. 4141, and H.R. 4191 will now come to order. Today we have a large number of witnesses present due to the number of bills and a high level of interest in some of these bills before us. Without any objection, the written testimony of all appearing today will be made part of the hearing record. However, the House also scheduled for some more votes this afternoon, so in the interest of time, there will be no questions for our first panel, which is comprised of members of Congress who are here to speak on their bills. Subsequent panels 2, 3, and 4 will not be asked to give in an opening statement today, but we will begin questioning and respond immediately upon their introduction. Each testifier's full and written testimony will be submitted for the record. Also, in the interest of time, I'm going to forego a lengthy opening statement and just briefly touch on one of the bills on today's agenda, which I am proud to introduce, which is H.R. 4095, the Veterans Compensation Cost of Living Act, or COLA, of 2014, which provides a cost of living adjustment increase to veterans' disability compensation rates and other benefits. The amount of increase will be determined by the Consumer Price Index, which also controls the cost of living adjustment for Social Security beneficiaries. As many of us here today know, the cost of living increase is beneficial to the veterans and their families who depend on VA benefits to make ends meet. Although I am very supportive of this annual legislation, I would like to once again state that it is unfortunate that we have to pass such a bill each year, and would encourage our colleagues in the Senate to pass H.R. 570, the American Heroes COLA Act legislation, which I authorized an annual COLA without requiring congressional action. This was ensure that the Veterans COLA is not tied to political action nor inaction in Washington. I appreciate everyone's attendance here today, and we'll now call on the ranking member for her opening statement.
Thank you, Mr. Chairman, and thank you for having the hearing. As you said, we're examining 10 bills that pertain to issues that are of great importance to our nation's veterans and to those in this room. I support a number of these bills. And first, I'd like to say that I'm proud to have worked with the chairman to introduce H.R. 4095 and H.R. 570 that deals with the Veterans Compensation Cost of Living Adjustments for 2014. Like you, I wish we could make this permanent, but in the short term, we certainly need to raise the compensation for this year. It's simply the right thing to do, and I thank you for that. Also on today's agenda is H.R. 2088, which is introduced by a ranking member of the full committee, Mr. Michaud, which would create claims processing centers of excellence. With the ranking member here to discuss his bill, I'll defer to him to outline the legislation, but I want to say I fully support this legislation and believe that it will build on the VA's successes to date fighting the backlog. H.R. 2119, which is the Veterans Access to Speedy Review Act, is brought forth by Dr. Ruiz, a member of our subcommittee. His legislation seeks to address the appeals backlog, which we know is a high priority for this committee, and it would allow the Board of Veterans Appeals to select the quickest ways to schedule hearings for our veterans, and he is here to address that. Also, H.R. 2529, the Veteran Spouses Equal Treatment Act, would clarify the definition of spouse for the purpose of receiving VA benefits. So it would include all spouses in any legally recognized marriage with a veteran in any state of the United States and its territories and possessions. The purpose of the legislation is to bring the VA in compliance with the Department of Defense and other federal agencies to ensure that all veterans and their families are receiving the benefits they've earned throughout their military service. Unfortunately, current law precludes some veterans from receiving the benefits that they've earned. I believe this is a common sense approach, and I hope we can move the bill to the floor as quickly as possible. So I thank all of our members and our colleagues for bringing forward their thoughtful legislation to help veterans, and I thank our esteemed witnesses who have come today to give us some insight and answer our questions about this proposed legislation. Thank you, and I yield back, Mr. Chairman.
Thank the ranking member. With that, I'd like to recognize Chairman Miller of the full committee for an opening statement.
Thank you very much, Mr. Chairman, for yielding. I want to make a few remarks on two bills that I've introduced, H.R. 3671 and H.R. 4102. First of all, H.R. 3671 expands the eligibility for a medallion furnished by the Secretary of Veterans Affairs, which would signify that the veteran has veteran status of a deceased individual upon a private headstone or a marker. Currently, VA has the authority to furnish, upon request, a medallion for eligible veterans who died on or after the 1st of November of 1990. H.R. 3671 would remove the date of death limitation by codifying eligibility for the medallion benefit regardless of the veteran's date of death. For nearly 40 years now, VA has administered various programs to provide headstones or marker options for veterans. At times, there have been allowances for private headstones, and at times, those allowances were not provided for. The programs have evolved over time, and that evolution is somewhat confusing for veterans and their loved ones. Some view the current November 1st, 1990 date as an arbitrary qualification for the medallion. But in fact, this 1990 date was not arbitrary at all. It was delineated as a starting point for the medallion benefits because from November 1st of 1990 through the 1st of September of 2001, VA did not pay a benefit for the purchase of a private headstone or marker for a veteran who were qualified for interment in a national or state veteran cemetery. However, in 2001 through 2006 pilot program, a VA-provided government headstone and marker to eligible veterans regardless of whether or not they had privately purchased a headstone. And in 2007, VA actually made this program permanent. At that time, VA included a medallion as an alternative option, retroactive to the 1st of November of 1990. The medallion has proven to be very much appreciated by veterans and their families, and VA is supportive of the change to allow this option for more veterans. Accordingly, I'd like to encourage all of you to support the broadened eligibility that is contained within H.R. 3671. And then additionally, I want to highlight to your attention H.R. 4102, which I've introduced along with Representative Wolarski, to clarify that the estate of a deceased veteran may receive certain accrued benefits upon the death of the veteran and for other purposes. This bill corrects a grave injustice that has resulted from the tremendous backlogs existing within the Veterans Benefits Administration and will prevent the occurrence of future incidents. The fact is that unacceptable wait times at the VBA regional offices have contributed to tens of thousands of veterans dying before their benefits are granted. While VBA currently reports an average days to complete figure of 285 days, I recall that we are not long removed from the agency's 2-year-old claims initiative, which focused on rating claims that have been pending for over 700 days. And as to appealed claims, while the Board of Veterans Appeals Chairman's report for fiscal year 2013 has not yet been approved or provided to Congress, we can anticipate a grim account as veterans' appeals continue to rise unresolved for 3, 4, or more years. Now, under current law, only a veteran's spouse or children under the age of 18 and dependent parents are eligible to receive accrued disability benefits in the death of a veteran's claimant's death. H.R. 4102 would provide another option for payment into the veteran's estate. To demonstrate the need for this bill, I highlight the experience of Indianapolis veteran Shelton Hickerson and his daughter, Sharon Hickerson Thurman. In 2000, Mr. Hickerson filed a claim for disability benefits. VA denied the claim, and Mr. Hickerson's appellate process began. Ultimately, on June 27, 2013, after more than 10 years, VA awarded Mr. Hickerson a 100% disability rating with retroactive pay in excess of $375,000. But sadly, Mr. Hickerson passed away the same day as the payment of the benefit. Mr. Hickerson was entitled to this compensation, and had he lived just one day longer, he would have been able to deposit that accrued benefit properly into his account. However, he did not, and his daughter was not eligible to receive the accrued benefit because she was no longer a dependent. VA's errant and dilatory processing of Mr. Hickerson's claim resulted in no benefit to Mr. Hickerson, to his estate, and therefore his family received nothing. There's no doubt in my mind that VA will make mistakes in its claims rating process. However, the party to the transaction that pays a price for these mistakes should not be the veteran or the families of those lives who are also affected by illness or injury caused by their service. So I want to encourage all of you to support H.R. 4102, a bill to clarify the estate of deceased veterans may receive accrued benefits upon the death of the veteran and to provide relief in the case of Mr. Shelton Hickerson. Mr. Chairman, thank you for your time. I yield back.
Thank you, Chairman. With that, I will recognize Ranking Member of the full committee, Mr. Michaud, for an opening statement.
Thank you very much, Mr. Chairman and Madam Ranking Member. I'm here to testify on H.R. 2088. Today's veterans are filing the most complex claims in history, with the trend continuing towards an increase in complexities. These claims take longer, require more training and additional oversight to properly adjudicate a TBI claim than a loss of hearing type of claim. My bill seeks to replicate the success that the VA has had with specializing claims related to Camp Lejeune and atomic veterans. VA suggests that the centralization and specialization of these claims has allowed them to increase training and mastery of these complex conditions, thereby increasing timeliness and accuracy of the adjudication. The VA OIG recently noted that their inspection of a VA regional offices that 31% of TBI claims reviewed showed that staff has made errors. After informing the staff of the errors and VA taking action, the VA OIG returned and noted that 29% of the TBI claims reviewed were still found to be in error. I believe that my legislation provides a common sense solution that will result in veterans with complex medical conditions having their complex condition adjudicated at a VA Center of Excellence by a specialist who has been trained to adjudicate these specific claim conditions. We must continue to work towards and achieve a claim system that live up to the service and sacrifice of our veterans, so that no veterans will end up in a situation that you just heard from Chairman Miller with that veteran and their family. And with that, Mr. Chairman, I yield back.
Thank the gentleman. I know Mr. Ruiz wants to make a statement. Is there anyone else that wants to make an opening statement? So with that, Chair recognizes Mr. Ruiz for his statement.
Thank you very much, Mr. Chairman, for holding this legislative hearing. The bills we will be discussing today serve as a testament to our committee's dedication to the honorable men and women who have served our country. I thank the chairman for including my bill, H.R. 2119, the Veterans Access to Speedy Review Act, in the legislative hearing today. My bill seeks to address the appeals backlog by increasing the use of video conferencing during an appeals hearing as a substitute for the veteran being there in person. This bill intends to relieve the burden on veterans having to travel for VA appeal hearings in person. Many times this travel comes at a great physical and financial cost to the veteran. This bill is also focused on making the VA appeals process as efficient as possible in order to reduce the appeals backlog and create a more speedy review process. In working with veterans service organizations, we have found ways to improve the language of the bill to ensure it meets its intended purpose. I really do thank the VSOs, my Veterans Advisory Group, and the veterans in my district for their input. This is really their creation. I appreciate the chairman's willingness to include this bill in today's legislative hearing, and I look forward to working together to move this legislation forward. Thank you, and I yield back my time.
Thank you. And at this time, I would like to welcome my colleagues in the House to the witness table for our first panel. First, we will hear from the Honorable Al Green from Texas, who is sponsoring H.R. 3876. Next, we will hear from the Honorable Tim Walz from Minnesota, who is sponsoring H.R. 4191. Then we will hear from the Honorable Jeff Denham from California, who is an original co-sponsor of H.R. 4191. And finally, we will hear from the Honorable Steve Stivers from Ohio, who is sponsoring H.R. 2018. Additionally, Honorable Andrew Crenshaw from Florida is sponsoring H.R. 4141. He is unable to attend this afternoon as he is chairing a Financial Services Subcommittee of Appropriations currently. Noting that his full written testimony will be included in the hearing record. I'd like to welcome all of you to this legislative hearing. All of your complete and written statements will be entered in the hearing record. And with that, Congressman Green, we will start with you, and you are now recognized for 5 minutes for your testimony.
Thank you, Mr. Chairman. I thank the ranking member as well, the full committee chair, and the full committee ranking member. And I am somewhat moved, to be quite candid with you, by the comments about the Hickerson family. So I have to digress. It would be unlike me to let this go by and not say something. It pulls at my heart to know that a family is not in a position to receive something that has been earned. And I just don't know how to express my feelings about that other than to say, you didn't ask me, but that's something that I would support, this piece of legislation. All of the legislation that I've heard spoken of appears to be legislation that would greatly benefit our veterans. I'm just pleased that I came to hear what I've heard so far. So thank you for this. I'd like to start with a brief vignette that will give some indication as to why I feel the way I do about our veterans. I was in another state and lost, looking for a given venue. When I couldn't find it, I happened to look over my right shoulder. There was a VA facility there, and there was a sign that read, "Come in and see the price of freedom." Come in and see the price of freedom. And you and I know that the price of freedom is more than gold and silver. It can be an arm, a leg, or possibly someone not returning home at all. This is why we are concerned, and this is why we call to the attention of this august body, H.R. 3876, that deals with burials with dignity. We want every person who serves our country honorably to have a dignified memorial service. My hope is, after having talked to the representative from the VFW who is here today, that he and I and others will be able to work out some language that will be acceptable for this committee to review. Hence, I will not go into a long dissertation about the intricacies of the bill. I will simply say that it provides homeless veterans, those who may die with no money, or they may have no relatives to be of assistance to them, to make sure that they get a decent burial. Other legislation has addressed this. This is not to say that our country is not doing a good job. It is only to say that we believe that we have more to add so that transportation will be made available to these veterans. And there may be some other things that we're going to work out with the VFW and other friends. So I want to thank you for allowing me this opportunity to be heard today. I will not consume more of your time than is necessary, but I do believe that given what I've heard and how I feel, I want to use just a little bit of my time to ask for a moment of silence for those families who are still having to endure wars, endure pain and suffering because their loved ones didn't return to them the way they left. This is my request, and I would simply lower my head for a moment of silence. Amen, and thank you.
Thank you, Congressman Green, and I can tell you, being in my 4 years on this committee and talking, working with the VFW through the committee staff, we usually come to very sensible and get a lot of things done around here, believe it or not, in this committee. So appreciate your willingness to chat with them and look forward to working with you to get what we can get done. Thank you.
Thank you,
With
Mr.
that, I'll recognize Congressman Waltz. You are recognized now for 5 minutes for your testimony.
Well, thank you, Chairman Runyon and Ranking Member Titus, and to the Chairman Miller and Ranking Member Michaud of the full committee. I would echo the Chairman's comments. It's a singular honor to serve on this committee, and to testify in front of you is humbling and an honor. I'm joined today by a group of young citizens from Waseca High School in Waseca, Minnesota, and I can't imagine a better place to show them how democracy is supposed to work and how we're supposed to work towards solving problems than this committee. So I thank you for that opportunity. I'm also going to be joined and backed up by my friend, Mr. Denham, who has been the staunchest supporter of our nation's veterans. We introduced a piece of legislation to tackle one of the issues. There are so many, as Mr. Green said, so many of these issues are so good and on it. This issue of the claims backlog, it is corrosive, it is wrong, it wears at the soul of this country, wondering why in the heck we can't deliver these benefits that were earned. And I know that there's good intentions, and I know that we're making progress, and I know that the VSOs who will testify afterwards and the VA officials, that we all want that outcome. But I think there's some good ideas out there. And I would argue that Mr. Denham, myself, and we have a Senate companion version that's been introduced, and you're going to see support across the board from the VSOs. This is the right thing to do. This piece of legislation, it's very simple. Our measure would simply allow local doctors to conduct disability medical examinations for veterans. This would conserve VA resources, cuts back on the long wait time at VA hospitals, enables quicker diagnosis of disabilities, and eliminates unnecessary trips to the VA for veterans in rural communities. Specifically, to further encourage use of private medical evidence, we're amending Title 38, United States Code, Section 5125, to provide that when a claimant submits private medical evidence, including a private medical opinion that is competent, credible, probative, and otherwise adequate for rating purposes, the Secretary will not request a VA medical examination. This legislation would require VSRs and RVSRs to document that private medical evidence was inadequate for rating purposes before ordering examination, which many times is unnecessary, duplicative, and slows the process down. The legislation requires the Department of Veterans Affairs to complete 2 reports for us, a report of 180 days after passage that tracks the implementation, and annual reports that track the most common reasons and disabilities for which claims with evidence submitted by non-VA professionals were denied by VBA. Our goal, and this is very, very simple, uphold the promise we made to our veterans by ending the backlog and getting the benefits they earned. We think it's the right way to go. There's folks out there willing to do it. We have a Senate companion version. You're going to hear from all of the folks who process these on a daily basis, the VSOs, county veteran service officers, and everyone is going to speak in support of this except for the VA. And I want them to talk to you about this, talk to you about why there it is. They know that I'm their staunchest supporter, but I'll be their harshest critic. Today, I think I come as the latter on the backlog. With that, I yield back.
Thank Congressman Waltz for that. And with that, I'll recognize Congressman Denham for his testimony.
Thank you, Chairman Runyon, Ranking Member Titus, Chairman Miller, and Ranking Member Michaud. Appreciate, as Mr. Waltz said, being on this side of the dais and addressing a very important issue. The Quicker Veterans Benefits Delivery Act. We have talked many times about delivering to veterans and getting rid of this backlog. It's certainly one of the largest goals of the VA, but yet we continue to have discussions on why it's not happening quicker. This bill is very simple. Just as an example, currently at the Oakland Regional Office of the Veterans Benefits Administration, which serves the veterans in my district, there are over 20,000 pending claims. 12,000 of those claims are 125 days or more. Nationwide, by the VA's own count, there are more than 638,000 pending claims. 360,000 of those are over 125 days long. Secretary Shinseki set the goal of eliminating the disability claim backlog by 2015. And this committee and Congress responded by providing billions in additional funding to improve technology, hire additional staff, and reform the rating process for timelier decisions. The VSOs were also a vital part of this total effort, working hand in hand with the VA to create fully developed claims process to certify claim packets before they're submitted so they can be swiftly approved. However, with these efforts are more important, we are skeptical that these initiatives alone will break the backlog by the 2015 stated goal. Congress needs to do more to bolster VA's current efforts to modernize its operations and promote further improvements in order to get veterans' claims compensation needs to be settled faster. With that in mind, Congressman Walz and I worked with the veterans service organizations, the VSOs, to draft the Quicker Veterans Benefits Delivery Act. The bill will require the VA to maximize the use of private medical evidence. The bill would allow veterans to see their own doctor instead of waiting for an appointment with VA physicians who are often overworked or far away from a veteran's home. Congressman Walz and I both represent rural veterans, many of them elderly, and the challenge of traveling long distances for an appointment is one of the biggest barriers to accessing their veterans' benefits. This bill will help remove that hurdle from the benefits claims process. I'd also like to thank, in closing, the VFW, the American Legion, and the Association of United States Navy. Thank you, and I yield back.
Thank you, Congressman Dunham. With that, I'll recognize Congressman Stivers for his testimony.
Thank you, Chairman Runyon and Ranking Member Titus, as well as Chairman of the Full Committee Miller and Ranking Member Mashad for holding this hearing today on my bipartisan legislation, H.R. 2018, the Honor Those Who Served Act. I want to thank Representative Beatty and Representative Teaberry for their help with this bill. The measure before the committee today will help make it easier to provide a headstone or marker for veterans who currently do not have a headstone and lay in an unmarked grave. You may know in 2009, the Veterans Administration made a rule change that required notification of next of kin before a veteran could receive an initial headstone from the agency. That regulatory barrier of obtaining approval for next of kin creates an especially high barrier on veterans from much older conflicts like the Civil War and the Revolutionary War, as well as homeless veterans that Congressman Green talked about earlier. In my state of Ohio and in many other states, there are researchers. In Ohio, the Ohio Historical Society is one that checks the archives, death records, military records, and genealogical records to identify and determine the identity of Revolutionary War and Civil War soldiers who are buried in unmarked graves. These groups can work to identify the next of kin, but sometimes those people can be removed 6 and 7 generations from that veteran, and it's hard to identify next of kin. I understand the rationale of this VA rule, but it has an undue burden on homeless veterans, as well as identifying and marking the graves of our veterans from the Civil War and Revolutionary War who sit in unmarked graves. Those who served in our military deserve our full support, especially those who gave their last full measure of devotion for this great nation. Our veterans, regardless of their era who've served, deserve better than to be marked in an unmarked grave. And that's why on May 16th of 2013, a bipartisan group of legislators introduced this bill. It would stipulate that if a next of kin cannot be found, the headstone application can be filed with the VA by a state veteran service agency, military researchers, local historians, genealogists, or anyone else familiar with military sources and methods that can identify a veteran's identity. You know, President Abraham Lincoln, in his second inaugural address, called for the country to care for those who shall have borne the battle and for the widow and orphan, affirming the government's obligation to honor those who served our nation. And in 1959, it became the VA's motto. Those who've given the final measure of service to our great nation deserve a final resting place with a headstone worthy of their dedication, commitment, and devotion. As one final point, I did hear that the Veterans Administration is not supportive of this bill because they believe they can fix this through a rule. I would note that they caused this problem through a rule and recognize they can fix it through a rule, but this subcommittee had a hearing on this bill 6 months ago, and the VA has, as of today, done nothing to move a rule forward to fix this problem, and I would ask this committee to take this bill to markup and move this bill forward. While I recognize it can be fixed by rule, The VA has done nothing to do so, and it's time to fix this problem for our homeless veterans and our veterans from previous conflicts who today lay in unmarked graves because a next of kin cannot be found. Thank you for your time. Again, I appreciate the chairman and ranking member for holding this hearing, and thank you for allowing me to testify today. I yield back the balance of my time.
Thank you, Congressman Stivers. And as noted, we'll forego a round of questions with the first panel. Any questions that anyone has for this panel? May they be submitted for the record. On behalf of the subcommittee, I thank all of you for your testimony, and you are now excused. And a vote having been called on the floor, there's four votes requested, so this committee will stand in recess for just about an hour. Committee of Disability Assistance and Memorial Affairs will now come to order, and we welcome our second panel to the witness table. Second panel consists of Jeff Hall, the Assistant National Legislative Director for Disabled American Veterans, Alexander Nicholson, the Legislative Director for Iraq and Afghan Veterans of America, Heather Ainsley, Vice President of Veterans Policy with Vets First, and Diane Zamato, National Legislative Director for AMVETS. Thank you all for being here today, and thank you for your patience. Your full and written testimony will be made part of the record of today's legislative hearing, and as previously noted, I guess we will start with questions. And I guess I'll just start with Mr. Hall and go down the row. My first question is about Chairman Miller's bill 4102 that would allow veterans to be paid to a veteran's estate if the veteran passes away while a claim is pending and the veteran does not have a eligible survivor. Since most of your organizations have seen these situations similar to that of Sheldon Hickerson, which the chairman highlighted in his opening statement, can you please share with the committee any additional anecdotes that you may have about the veteran who passed while awaiting VA benefits decision? Mr. Hall?
Yes, actually, thank you for the question. It reminded me of a story when I was a service officer in Chicago before I left to go to New York. It was one of the last cases I'd worked on. It was two sisters that had come in for some assistance. The sum and substance of the story is that the veteran waited nearly 2 years to get his claim processed, and when he did get his claim processed, before they authorized and paid him the award, he became hospitalized. And while it took months and months and months for them to authorize the award, he ended up passing away in the hospital before the payment was actually made. So the two daughters, who were no longer dependent children of him at that time, were not able to receive that benefit, and it was well over $100,000 that the veteran was owed. So therefore, not only did it take them so long to process the award, then the ability for the veteran to receive that money or his next of kin was not able to receive that, or his heirs. So DAV is fully in support of enactment of HR 4102 for those very reasons.
Thank you. Mr. Nicholson?
Thank you, Mr. Chairman. Obviously, given our demographic at Iraq and Afghanistan Veterans of America, we don't have any anecdotes to offer in terms of deceased claimants. But to us, this bill was a no-brainer. We're happy to join our VSO colleagues in supporting it. I think we were among those who did not realize that this was even an issue until some of the cases were brought to light in media, which is a way in which we learn about a lot of these issues and come to support things that need to be changed. So for us, this was a no-brainer, and we're happy to support the change.
Ms. Ainsley?
Thank you, Mr. Chairman. I would say that if I were to speak with some of our veteran service officers, they could probably provide some of those anecdotes. I personally do not have one to share, but do want to align myself with my colleagues that we certainly support the bill and the aims that it is hoping to achieve, and it certainly makes sense that we would do this as quickly as possible.
Ms. Amato?
I would agree with all the folks that have spoken before. I don't have any anecdotes to add, but AMVETS does support the legislation.
Well, I appreciate that, and I think you'll really have another question. I just want to touch on what I kind of said in my opening statement. I think you all agree with me that a permanent COLA needs to be accomplished. I see many nods up there, and I would appreciate any and all help that you all can do with that, because I think much like anything else around, unfortunately, like a lot of things around here, that it creates a lot of uncertainty for our veterans on what, when you have that lapse in that calendar is going to bring the following year. And it's unfortunate that we put our veterans through that time and time again when it's something that it's very bipartisan and it passes every single time. Why do we have to create that uncertainty? So I thank you all for your time, and I will yield to the ranking member for her questions.
Thank you, Mr. Chairman. And I thank all of you, too, for providing the thoughtful testimony and for your support and help with these bills. Mr. Hall, I know you highlighted in your testimony some of your concerns about H.R. 4095, and we heard Mr. Green, the sponsor of that, say that he was going to be working to come with some improvements to that bill. So I would ask you to work with him to see if we can do that. I know you mentioned the need for maybe a flat rate of payment, something like that. So appreciate having your input if we're going to further consider that bill. I would also say to Mr. Nicholson, we had some of your members in our office earlier today. They're storming the Hill, and they talked to us about we've got your back and some of the suggestions there, because the high suicide rate among veterans is just something that we have got to address, and we've got to do it at a personal level as well as a societal level, and that's the way your suggestions were, and I thought that was great. In your statement, you said you support the ranking member's bill that concerns the centers of excellence. I wondered if you might elaborate on that a little bit and how you think that will be helpful, and what other suggestions you might have for streamlining that claims process.
Yes, ma'am, we do. We have seen efficiencies found, I believe, in processes and innovations such as this. And, I would just say, though, that, we have certainly heard some of the concerns of our colleague VSOs and, echo those as well. But we think that those are, any kinks that they think may result as a result of this pilot program, and especially an expansion of it, can certainly be worked out. And we think a pilot is certainly a smart way to start. But we believe that innovations like this have proven useful in other types of situations with other types of claims, and we think it's worthy of at least a pilot to try it out with this, because there's no denying, that there's an issue still at the VA with handling these claims and with the backlog still. I mean, the VA has made enormous progress. Since, I think, like you mentioned, we are storming the Hill this year, and I think since we stormed the Hill last year at this time, the backlog is down 40%, which is fantastic, and we commend the VA for that progress. But we still have hundreds of thousands of veterans, each one of those an individual story, an individual life with a family who is impacted by this, and so we don't want to let up the pressure. And we do believe that we're willing to support anything that looks like it'll work, that has precedent, that works in analogous situations, and we believe this is one that's at least worthy of a pilot.
Thank you. I yield back, Mr. Chairman.
Thank the gentlelady for yielding back. And again, on behalf of this subcommittee, I thank you for your testimony. This subcommittee looks forward to working with each of you as the stakeholders in this as we perfect this and bring it to, I believe, a legislative markup in 2 weeks. So look forward to it, and you are excused, and I'll ask the third panel to come to the table. The third panel consists of Mr. Zachary Hearn, Deputy Director for Claims, Veterans Affairs, and Rehabilitation Commission for American Legion, Mr. Anthony A. Wallace, the Legislative Director and Director of Government Affairs, the Association of the U.S. Navy, and Brandon Gerke, Director of National Legislative Service for the Veterans of Foreign Wars. Thank you all for being here today. And as previously stated, we will go right to questions. And my first question, believe it or not, it's pertaining to HR 4191, the Quicker Veterans Benefit Delivery Act. Can any of you provide specific examples of a case in which the veteran had sufficient private medical evidence for the record, yet the VA chose to order an additional exam to determine the veteran? I mean, obviously, we heard some of it from Congressman Walz earlier, but we'd like to get the stories from you guys, the stakeholders, and your exact experiences with it. So, Mr. Wallace, any examples of it?
Thank you, Mr. Chairman. At this moment, I do not have any specific examples. However, I know that our Member Services Department does get a lot of claims questions and issues that arise, mostly because we have frustrated members upset that their claims are taking so long to be answered. And we do support HR 4191, the Quicker Benefits Delivery Act, as it seeks to help end the backlog of claims by conserving VA resources, enabling quicker, more accurate decisions for veterans, allowing private medical evidence documentation for such claims. So I feel like that we are comfortable saying that this legislation would help with streamlining a lot of those claims, and only seeks to benefit the veterans, so that physicians in the field and localized with these veterans in their community will be better suited to help the VA process these claims.
And let me ask this question, and we'll continue down the line to you again. Do you have any examples, anecdotes of Chairman Miller's bill 4102?
4102?
Yeah.
We do not have any specific anecdotes of that as well, but we understand and appreciate the legislation of itself that also helps to answer a question regarding compensation for claims as well. That this was a frustrating circumstance with the individual in Indiana and his family for getting the claims and compensation processed in a timely fashion. So we are appreciative of that. We don't have any examples at this time, but we are appreciative of the legislation.
Mr. Hearn?
Good afternoon, Chairman.
Yes, before I became deputy director, I worked for several years over the Board of Veterans Appeals, and we would routinely see VA scheduling superfluous examinations where the evidence was contained within the C file. I mean, it was self-evident. It didn't take a rock scientist to discover it. When we went out to the Seattle VA regional office, I want to say about 2 months ago now, I can think of one particular case where the veteran was going through the process of retiring, I believe. The evidence was contained in the veteran's military records to say that he had a certain condition. I believe it was sleep apnea. Despite that fact, they scheduled an examination, and it becomes counterproductive with the fully developed claims process, and it delays a process that is meant to be expeditious, and so it becomes an unfortunate scenario.
Thank you. Mr. Gerke, you have any?
In regards to HR 4102, I'd like to note that last year 19,500 veterans died while awaiting benefits. I've heard people joke that veterans who have deceased get quicker service from the VA than living veterans. That's obviously not true, but we really have no idea how many veterans have died before they received benefits who could not pass that on to their children. What's most frustrating about that to the children is they often take care of the veteran while he is ill, while he is on his deathbed, and really the veteran's benefits should be going towards that type of treatment, that type of hospice care for taking care of that veteran. So that kind of illustrates the real need for that, because it does present a financial hardship on the family. In regards to HR 4191, most of the stories that I've heard regarding this has to do with PTSD treatment. Because of the nature of PTSD and it being so urgent, veterans will often seek help from a variety of sources. Military One Source will connect veterans with Give an Hour, who will then give PTSD treatment to the veteran because of the urgent need of that. So we see that more often than not with them. This bill is something that all the independent budget VSOs have recognized as an issue, and something that we urge the committee to pass.
Thank you. With that, I'll yield to the ranking member, Ms. Titus.
Thank you, Mr. Chairman. Again, I would just note that some of you have suggested problems with Mr. Green's legislation and asked for your commitment to work with him between now and the markup, and I think that you've already established that. I would just ask a little more about HR 4191, maybe Mr. Hearn, if you want to comment on from all your accredited service officers nationally who assist veterans with their claims, how can we and the VA assure the kind of the proper use and acceptance of private medical information?
Just this past, or late last week, actually, the American Legion held a Department of Service Officers School, and we were able to bring service officers in, and perhaps in language more direct than drill sergeants at times, they will express their frustration regarding VA and the review of medical records from the private sector. One of the easier ways is for examiners or private sector physicians to utilize the disability benefits questionnaires, because it's a standard form. I understand that there's some frustration within the medical community sometimes with that, because they're taking something and more or less making it fill in the blocks or something along those lines. But it has proven to be far more effective, because it makes it a lot easier for raters to review that and say, it meets this criteria, it meets that criteria, and we can go ahead and rate it, and then it starts taking some of that gray area out.
I think in history and realizing the acceptance of private medical evidence, you have to realize that for a long time, VA gave work credit for rating officers who requested a disability rating examination. So they would get a claim, and they would get credit just for requesting it, whether they had the private medical evidence there or not. Much to VA's credit, they've gotten rid of that credit system. However, there seems to be somewhat of a culture there that rating officers will automatically do that out of habit and request that rating examination. There is also a little bit of a turf battle whether VA wants to do it in-house or they fear outsourcing of it. It really depends on the regional office is what we found. Some regional offices are better better at accepting than others, but we feel like there should be an entire standard throughout the VA in accepting private medical evidence. Secretary Hickey's done a lot of work on this. She started to, I believe she gave a memo saying that all rating officers will accept private medical evidence if the claim is older than a year. And the VA can correct me if I'm wrong on that, but we'd like to see it for all claims done, whether it's been backlogged for a year or two, or whether it's starting now. Because if it doesn't happen, it takes 180 days just to get a rating examination on average, 120 to 180, I believe. And so that's, I mean, essentially the backlog right there. So you can eliminate a lot of that with that portion.
Thank you. That's helpful. Yield back, Mr. Chairman.
Thank the gentlelady. And gentlemen, I thank you for your patience and your testimony today. And with that, this panel is now excused, and I welcome the fourth panel to the table. On this panel, we will hear from Mr. Thomas Murphy, the Director of Compensation Service with the U.S. Department of Veterans Affairs. He is accompanied by Patricia Lynch Watts, the Director for Legislative and Regulatory Service for National Cemetery Administration with the U.S. Department of Veterans Affairs, and Mr. David Behrens, the Deputy Assistant General Counsel for U.S. Department of Veterans Affairs. Thank you all for being here today. And as previously noted, I will now begin questioning. First of all, Mr. Murphy, regarding HR 4095, the annual COLA legislation, do you think veterans would benefit from having automatic COLA rather than an annual COLA, as provided in my previous bill that was passed this House, which was HR 570?
Yes, Mr. Chairman, veterans will directly benefit from this. It keeps the benefits they receive in pace with inflation, just like is administered in Social Security today. It makes it easier for VA to plan and implement these. We know it's coming. It's on a consistent basis, and we're not waiting on a law to be passed at the last minute. This bill is just good all around.
Thank you. Regarding HR 2018, one of my constituents previously inquired whether it would be feasible to create a special exemption for veterans who died in the 1935 Labor Day hurricane. This addition would require the VA to provide group burial memorials for those men who died while enrolled in a Veterans Work Program, a federally funded project that during the Great Depression. 244 veterans remain buried in 2 unmarked mass graves in Florida. Whether by statute or regulation, would it be physically unfeasible or cost-effective to provide individual grave markers or a group burial memorial at these sites?
Sir, I have to defer to Ms. Watts on this one.
Okay. Ms. Watts?
Thank you, Mr. Chairman. The specifics of the cost of providing individual stones on that, I would have to take back for the record. I don't have information on exactly what the cost would be.
Okay. Would you submit that for the record, please?
Thank you.
Thank you. This would also be for Ms. Watts then. Can you elaborate on VA's strong support of HR 3670 and specifically on your recommendation that the legislation change the medallion eligibility to date to on or after April 6, 1917, rather than eliminating the date altogether?
Yes, thank you for that question, Mr. Chairman. We're concerned about preserving the historical integrity of the headstones and markers from periods earlier than that. To provide the medallions on headstones that predate deaths prior to our entering World War I might impede our ability to preserve that historic integrity in those places. So we would respectfully ask that we be able to limit that back to the beginning of World War I, deaths back to that date.
And one more question about HR 4141. In the VA's written testimony, it's noted that the VA believes that the bill should allow enhanced use leases on any and all underutilized and/or vacant VA-controlled properties. Can you explain how this authority would be beneficial to the department? And likewise, can you explain the concerns you have regarding the language as currently drafted regarding the land that is unsuitable for burial purposes?
Yes, sir. The ability for VA to use land that we are not currently using, but that is usable land, would be helpful with this enhanced use authority. However, I believe the department is concerned about the language, as you said, that limits it just to NCA burial land, or lands that's not used for burial. Our concern about the language was that it was specifically that it not be suitable for burial, and what we would recommend is that the language be changed so that it is land that's not going to be utilized for burial for the period of the lease. That would allow us to use land that possibly is indeed usable for burial, suitable for burial, but that we have no plans in the immediate future to use it for that reason.
Thank you. And with that, I'll yield to the ranking member, Ms. Titus.
Thank you, Mr. Chairman. I'd like to thank the VA for your assistance on the bills that are before us today. I appreciate your working with us, and we're looking forward to receiving some of the cost estimates. I'd like to ask you, Mr. Murphy, in your written statement, you argue that the VA is looking to increase productivity and decrease wait times through a variety of initiatives. Now, the Reno office has struggled to implement any new systems. I give you the example of VBMS. So I wonder what you're doing to ensure that some of these underperforming regional offices are going to be able to effectively implement these initiatives that you're talking about.
We don't have enough time to go that in an in-depth answer.
We got lots of time. Go ahead.
Okay. Excuse me. For starters, we had an additional appropriation in 2014 of $10 million to provide for training in the underperforming offices. And one of the ways we're focusing that is in offices such as Reno, where the individuals are underperforming, and it's due to an individual's performance, lack of training, lack of skills. Much like what we did with the SET training in 2013. The other one is that the other part of that question is what other things are we implementing that are going to improve that production, improve that facility. It's the use of centralized mail, the use of stakeholder entry portal for veteran service organizations, the continued use of overtime that you're seeing that goes on today. There's a myriad of other people, process, technology improvements that are driving that today. And while we're driving that and moving forward at the same time, we have to keep an eye on offices that are underperforming and not keeping up with the rest of the pack in the improvements in production and quality that we're seeing. And thanks to Congress, they've given us the money and the resources in order to do that during this fiscal year.
Well, I appreciate that. Also, in the testimony that we heard earlier, that we referred to earlier from both the American Legion and the VFW, there were some serious concerns expressed about the communications between the VA and the VSOs on brokered claims. And we've experienced this in Nevada too. Reno is kind of dealt with its backlog by brokering out about half of its claims to other places. And so I wonder if as all these initiatives are going in place and you're brokering more and more of these claims and you're implementing this national work queue, do you have a communication strategy in place of working with the VSOs so they know what's going on and how to track these claims? And if you don't, can you get one? Can you make one, or you have
Yes,
plans to make
we
one?
absolutely have a strategy. And look, the communication is the key. If I can have an early communication with the Veteran Service Organization representing that veteran, pre-decisional, which they have the right to look at that file for 24 hours, it doesn't do me any good for a power of attorney in Reno to not have access to a case that's being decided in North Carolina. It's in the veteran's best interest and the VA's best interest to allow that VSO the time to take a look at that case. And the way we have to accomplish that is through the use of the stakeholder entry portal by allowing full access to VBMS and the file in an electronic environment so that the power of attorney representing that veteran can give an accurate assessment of the work that's been done before we finalize that claim. If I don't provide that, then it simply just adds up to another appeal that we have to deal with down the road. So,
Could you share with us that communications plan, copy of that plan?
yes.
Okay, thank you. I yield back, Mr. Chairman.
Thank the ranking member. I have one more question, I believe directed at Mr. Murphy, pertaining to HR 4191. You've said in your testimony that the authority already exists for the VA to use private examinations, but I can tell you a lot of people I know on this staff here and the stories we hear, they don't feel like they're given the proper weight all the time, and it feels like a rater almost defaults back to the VA automatically. Is there anything that you can do or have done or training you've put in to guide them to say, this is a legal process and we need not to continue to burden our veterans and lengthen this period of time?
The statute and our regulations don't just provide for, but require the rating of a case when the evidence is sufficient and meets a very long list of things that need to be met in order to rate a case. and the part of the question about what have we done to provide for that? What we've done is we put out a policy from the national level that essentially error-proofs a case. So the individual is not held accountable if they use a DB-CLIU, which is completed, submitted by the veteran, to rate the case. If that case later results in an error, that error will not fall back to that individual. In other words, it's the system fault that I need to go back and deal with at a different level, and there's no repercussions back to the individual for performance or for quality. So I've put the right protections in place to put the right behavior in place on the part of our raters.
Just one last thing. You also note that the VA does not track the number of claims eligible for ACE that requires additional evidence obtained through telephone interviews, or whether private medical evidence is sufficient for rating purposes. And my question is, why isn't a process like that being tracked?
That is one of the things that we need to be tracking going forward. But coming from the paper environment that we have, bring it into the automated world that we have today, we don't have all the steps and features in place that I can get the development detail to that level. That's certainly something that's on our radar to be put in place. And what that will do is it'll allow me to do, like several other systems, it provides me an opportunity to look at the exceptions and find out, is it an individual, is it a particular office, is it a particular process that I need to go back in and address. So it's one that we're developing and putting into the system. It's not there today, however.
And just one more question to follow up to what Ms. Titus had. She was asked what the $10 million is used for. As arguably the training regimen was developed already, what is the significant dollar amount? And while we complete the support and enhance intelligent training, what does it pay for?
What does it pay for? We are funded today to do our challenge training program and other training events. This provides dollars well above and beyond to allow us to pull in people that would not otherwise be trained in 2014. And we can target and focus at specific underperforming individuals. The dollars we have in place today takes care of new employee training, employees that have been promoted already. Well, if I'm going to go out and make a difference in the environment on a large scale and pull underperforming employees in on top of that, that's where this additional funding comes in place.
Okay. Ms. Titus, anything further?
No, thank you, Mr. Chairman.
Well, Thank you all for your testimony and answering the questions. On behalf of the subcommittee, I want to thank you for your testimony again. As noted, your written testimony will be entered in the hearing record, and we'll inform the discussion on the legislation we have heard about today. We look forward to working with you in the future on these bills, as well as a wide range of challenges facing our nation's veterans. You are excused. I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include any extraneous material. Hearing no objections, so ordered. I thank the members for their attendance today, and this hearing is now adjourned.